Next case set for oral argument this morning is State of Ohio versus Ray Owens. That's case number 29098. The State of Ohio has waived their oral argument in this case as well, so we will hear from Attorney Buchanan, yes, on behalf of Mr. Owens. We've read the briefs and are prepared to proceed. You are, as you know, they are recorded, so keep your voice up. Attorney Buchanan.
Thank you, Your Honor. May it please the Court, I am Attorney Wesley Buchanan. I have the privilege of representing Ray Owens, who is the appellant in this matter. As indicated, the government has waived their oral argument, so I do not have the opportunity for rebuttal. The old adage that some of us are taught is that if you represent yourself, you know, fool for applying. And that seems to be kind of the heart of the issue here with Ray. This court has set forth in State v. Regal, 2005, Ohio 590, paragraph 12, reviews the waiver of a counsel in the totality of the circumstances. Here, the trial court indicated in sentencing, based upon information that was found at the PSI, that there may have been some substances in Ray's system that would have indicated his willingness or ability to waive his right to counsel. Now, standby counsel in this case was appointed and did sit during the trial and did help Ray make the necessary procedural motions as the trial court indicated. At the heart of this matter was Ray was given the opportunity, I shouldn't say plea colloquy, but a waiver colloquy was taking place for the first 6 counts. And those counts were enumerated in the written waiver that Ray did execute and did file with the court. The government then went back and supplementally indicted Ray on counts 7 and 8. There is no record of a written waiver for specifically counts 7 and 8. Following a jury trial, Ray was convicted, and the trial court imposed the maximum on counts 7 and 8, which were felonies of the second degree, which was 8 years. So there was no written reported waiver of the right to counsel specifically to counts 7 and 8. And this court, looking at the totality of circumstances, the court did inquire, but I think what the trial court did was merely take the waiver of one for the waiver of all. And in this case, because there was an intervening event, and that intervening event was the supplemental indictment, Ray should have been given the opportunity to make the choice, do you still want to represent yourself? So his position is that his waiver was not voluntary, and indicated, at least at sentencing, the trial court did have some questions about Ray's mental state, which would at least warranted a follow-up, if not a delay in the request for a waiver. If, for instance, during the colloquy, Ray was asked the questions, are you taking any prescription medication or anything of that nature, and he would have answered in the affirmative, then the trial court would say, okay, that's fine, we'll come back at a later date for the waiver. I mean, that would have been more better procedure to do so. And Criminal Rule 44 requires the waiver to be recorded. Now, this court in State v. Trachillis, I think I'm pronouncing that correctly, 2005, Ohio 4266, paragraph 14, indicates that a signed written waiver is the preferred method. However, it would be harmless error if the trial court substantially complies with Criminal Rule 44. In this case, I don't believe the trial court, and Ray doesn't believe the trial court complied with Criminal Rule 44 because, again, there's no written waiver for counts 7 and 8. In addition, counts 7 and 8 were possession and trafficking of heroin. At sentencing, Ray would indicate that those offenses should have merged. In addition, counts 3 and 4 were, again, possession and trafficking, which should have merged. No objection was made at sentencing, so this court would look at it at a harmless error standard, but that's why Ray is issuing those errors. Now, again, Ray's position is the totality of the circumstances. Looking at the transcripts, Ray consistently asks the court, I do not want to contract with you. And this is a criminal case. It has nothing to do with contract law. So the transcript is replete with him asking that question a few times. So I don't know if the trial, I'm not asking this court to reverse and remand for competency or NGRA because he would have had to raise that. But what Ray is asking is that he reverse the trial court to demonstrate that his waiver of counsel was not voluntarily, intelligently, and knowingly entered into based upon the totality of circumstances and based upon Ray's own conduct at trial. The trial court can only be asked so many times, I don't want to contract with you before a question should be raised, what is going on?
How do you counter that with the state's argument that he's alleged to be a sovereign citizen and he got this theory from his mother?
Well, in the government's position of him being a sovereign citizen is that the Supreme Court has already promulgated methods for which a trial court can engage in as far as the sovereign citizen movement, if for lack of a better term, is concerned. The trial court has said, listen, this is a criminal case, this is not a contract case. Do you really understand what you're doing? The government is alleging you've committed these crimes and can say on the record in open court, this is what is going on. This is what is occurring. Do you understand? Now, if he says yes, that eliminates the sovereign citizen argument. It's not a matter, it takes it out of that position of whether or not he is a sovereign citizen or even because it's a frivolous argument, but it gives the trial court more of a record and this court more of a record to say, listen, okay, the trial court did what they needed to do. Because the better procedure would say, okay, Ray, do you know why you're here? I have no idea why I'm here. I don't want to contract with you. Okay, well, do you understand that the government is alleging you committed these offenses? Now, and we're not asking the trial court to do anything that they normally wouldn't already do, either in a plea colloquy or in sentencing, or at least at a waiver hearing for the right to counsel.
Let me go back to count 7 and 8. Let's say that we would find that the written waiver itself was valid under the totality of the circumstances, that, you know, the court has substantially complied with 44 and everything. You know, if there's any little problems, they were little and harmless, okay? But then we said count 7 and 8 did not have a waiver. What would happen then?
Well, the remedy would be a new trial for Ray, at least on those counts.
That's what I was wondering, you're not trying to argue that he should get a new trial on everything then?
Correct.
If that's the case.
Correct, yeah. If this court finds that there was a valid waiver for counts 1 through 6, and I say 1 through 6 only because that's how the indictment was, because 1 and 2, I believe, were dismissed because of the weight, and they had to be supplementally indicted. So if this court were to find, yes, there was a valid written waiver, and totality of circumstance indicates there is a written waiver, and the trial court did comply for 1 and 6, we're not worried about that. Ray is more concerned with count 7 and 8 because those are the counts ultimately that is the reason why he's in prison for 8 years. Because currently he's incarcerated, and the trial court did give him the full 8 years for those felonies in the second degree. So he should be entitled to a new trial and permit him then, if he would like to, for the trial court to then substantially comply with 44 and say, are you sure this is what you want to do? Your eyes need to be wide open. I mean, that's really what it's supposed to be. Are you sure? Are you sure? Are you sure?
I'm sorry, go ahead.
Counts 1 and 2, you said were dismissed. The indictment is supplemented with 7 and 8. I just want to make sure, were they the same acts and circumstances involved in 7 and 8 that were involved in the dismissed ones?
I can't speculate as to the true reason why the government supplemented that. I can only infer that I believe it was the weight of the contraband. I believe is what the supplemental indictment, because I believe it was decided on a weight, and that's what made it a felony.
Everything was the same except for they reduced or increased the amount of the
Correct.
weight of the contraband.
Everything was the same, except it changed the nature and the penalty of the crime. So that was really the big deal, because it was to raise benefit. The other thing is that the written waiver, in the totality of the circumstances, it didn't indicate PRC. Because on a felony in the first degree, PRC in this case would have been mandatory, and in the written waiver, and I think it was not spoken about during the colloquy, that was not brought up. So as far as substantial compliance is concerned, I would indicate that the Supreme Court and this court has held numerous times that PRC has to be indicated, and the remedy is to resentence on that issue. But for this waiver issue, I would indicate that knowing that about post-release control, whether or not it's mandatory versus discretionary, is very, very important, whether or not you're going to waive your right to counsel.
And you have case law that says post-release control has to be mentioned during a waiver?
No, I'm just...
I know it does that sentence.
Correct, sentencing, that's what I'm indicating. I have not found anything that it has to be mentioned at the waiver of counsel. I would just indicate that because it is a substantial piece of information, I believe that it should be mentioned at the trial court level.
As to your fourth assignment of error, do you believe, or do you agree that Roth applies to that analysis?
I would. As far as the merger issue, Yeah, there was no objection at the sentencing, and this court would have to review it on the harmless error standard. So I would agree that that is the correct standard that this court has to review it on. That is certainly our position, and that's what Ray would be saying as well. And with that, if the panel does not have any other questions,
You're good? Okay, and I don't have questions either, so thank you very much for your argument. We'll take the matter under advisement, issue our decision, and of course, we'll certainly mail you a copy. You could also check the Supreme Court of Ohio's website, as you know.
Thank you
very much for your argument this morning.